The Special Needs Trust is providing for the special needs. Now, what are these special needs? It could be anything from medical care to dental care to recreation to education to the ability to travel, the ability to go see movies, whatever the case is. I have one client, she has a brother who lives in Nebraska in a group home. She goes to visit him 3 times a year. She's the trustee of his special needs trust, and she's able to have the trust pay for her travel to go back and forth to visit him. There's plenty of assets to do that, but also she goes out there and she basically takes care of him when she's there, but she gives him a bunch of extra stuff. She buys him TVs and CD players or DVD players, DVRs. She makes sure he's got a full stock of movies, to watch. She takes him to the movies. She gives him movie passes. Things that you're allowed to do. It's not countable. It's not a countable resource that might disqualify you for governmental benefits. But these are supplemental things that you can give. She makes sure that he has dental care, which may not be covered by state or government benefits. She makes sure that he's got absolutely top-notch medical care that might not be covered by these programs. And that's what the special needs beneficiary is going to get out of this. It's also giving comprehensive estate planning to your clients. Any questions on special needs trust? It's more complicated than the way I describe it. If you read the care manager provisions in these special needs trusts, they go on for about 4 or 5 pages because it's really specific, and it may be tailored to the needs of the special needs beneficiary. We've had a lot of clients with autistic children who've created these special needs trusts. Clients with children who do suffer from mental disabilities, bipolar disorder is one of them, schizophrenia. It's not uncommon, and as the child ages, so they become older than age, say 15, 16, those disorders begin to manifest themselves. You start to see them, and you want to provide for them. You want to make sure that the child is not cut out, but also not given too much, and it's also handled properly. So gun trusts. Why do we need a gun trust? Well, the Gun Control Act of 1968 contains 2 titles. Title I deals with rifles, shotguns, regular handguns, which is probably the biggest area of debate today in whether or not access to these firearms should be federally regulated and more regulated. Of course, it's a Second Amendment issue because the right to bear arms is in the Second Amendment, but Congress, at least as of 1968, and hasn't changed, has delegated authority for regulating handguns, rifles, and shotguns to the states. So the state of Virginia has its own laws, DC and Maryland, open carry states. You've heard about all these different rules. That's state law. That's Title I of the Gun Control Act of 68. It says, states, that's your province, we're not going to interfere. That may change in the future. And if it does, this will impact it. But it may not change in the future. And if it doesn't, the states regulate it. The gun trust idea really centers around Title II of the Gun Control Act of 1968. It's known as the National Firearms Act, the NFA. What does it cover? Well, machine guns, silencers, automatic weapons, and all these other things, suppressors or silencers. I have a client who has a tank. I have another client who has bazookas and rocket launchers. We have relationships with a lot of clients who served in the military, who love their weapons. A lot of these weapons are Class 3 firearms. Under the Gun Control Act of 1968, as currently regulated by the Chief Law Enforcement Officer, CLEO of the United States, you have to file certain forms with the Treasury Department to register your right to possess these firearms. And if you do not do that, it is a criminal violation of the Gun Control Act of 1968, and it could be treated as a felony. What happens if you have these weapons and you die? You cannot leave them to a child in a will, even if you want to. It would be a violation of the Gun Control Act of 1968. So this is why these gun trusts have come about. We've come up with a way of setting up a revocable, not irrevocable, a revocable living trust just for the purpose of owning Class 3 firearms. And I've got several clients who have gun trusts. We've set them up for our clients. And if you've got clients that have Class 3 firearms and also want to regulate the possession and passage of their non-Class 3 firearms, their regular rifles and guns, use a gun trust. It allows for you as the trustee of the trust and the trust beneficiary during your life to own a Class 3 firearm and use it and possess it and do anything you want with it. If you want your child to have access to a Class 3 firearm, hopefully it's somebody who's mature and old enough to handle these types of things, you can also use a gun trust to enable them to do that. They have to have a letter of authorization from the trustee, and anytime they're walking around with their bazooka. If they're walking around with their bazooka and they don't have this letter of authorization from the trustee, they could be arrested and put in jail. So it's a good idea to make sure that they have the right paperwork with them. But what this does is, when you die, you don't have to re-register all of these firearms with the federal government. They're already registered with the trust, and they pass on at your death through the trust. The trustee is the only person that is on record with the federal government, and it's just a notification requirement. So it's really easy to handle these types of firearms and your guns if you want to pass it to the next generation. So I've said all this.
Wait, what happens if something happens to the trustee?
You name successor trustees, just like you do in your revocable
And
trust.
the person has to file
All they have to do is send a notice, and just it's a matter of record. But there's no re-registration. There's a Form 4 that has to be filed when you originally register these weapons with the federal government, and it's a really I've filled them out for clients. Really complicated form. Where you bought it, describe the weapon. There's an ID number usually on the weapon. The price that you paid for it. Everything has to be. It's fully a matter of federal record. So the gun trust, as I explained, is a special purpose revocable trust. You keep it separate from your regular revocable trust because you don't want the federal government necessarily seeing everything else that's in your revocable trust. This is solely for the purpose of passing on ownership and title to Class 3 firearms. You can amend it, revoke it at any time. You don't have to notify the federal government. They don't even have to get a copy of the gun trust. They just have to be told that it's owned in trust. And the main thing is, if you name a successor trustee and name beneficiaries, it avoids the need to go back and re-register with the chief law enforcement officer of the United States. It avoids probate too. So protecting you from criminal liability, allowing you to pass it on to the next generation. And in this area, we represent a lot of government contractors. A lot of those government contractors came out of the military. A lot of those military guys and women love their guns and they love their weapons. And this is another special tool in your estate planning arsenal that we hope you'll take advantage of.